Hey guys, it's been quite a while actually since I've done anything. Just been enjoying a little break with my family, so that's why I've been a little bit quiet. There hasn't been too much, although I am a bit late to the game with this one, because I didn't get the notification about it actually, and I've not really been on social media. But here we are. So this is quite a short judgment just to go through. It's only 8 pages long. Okay, so let's have a look at this. In this anti-SLAPP action, plaintiff, the New York Times Company, seeks an award of attorney's fees from defendant Wayfarer Studios, following a ruling in New York Times Company's favor in an earlier federal defamation action that Wayfarer had brought against it. New York Times now moves for summary judgment in its favor. Wayfarer Cross moves to stay this action, pending the resolution of trial court proceedings in the related federal action. New York Times motion is granted with respect to liability and granted in part and denied in part with respect to damages. Wayfarer's cross motion is denied as academic. Okay, so background. On December 21st, 2024, the New York Times published an article called "We Can Bury Anyone" inside a Hollywood smear machine, accompanied by a video discussing actor Blake Lively's sexual harassment and workplace retaliation complaint arising out of working on the film It Ends With Us, produced by Wayfarer. Lively had filed the complaint in California State Court. No, she hadn't. It wasn't filed in a California State Court. It was filed with a California Civil Rights Department. Lively had filed the complaint in California State Court against Justin Baldoni, the director of the film and Wayfarer's co-founder, and James Heath. What? It's obviously not James Heath, it's Jamie Heath, Wayfarer's CEO and the film's head producer. The Times article and video relied solely on Lively's complaint filed with the California Civil Rights Department, in which she alleged that Mr. Baldoni and Mr. Heath engaged in misconduct on the set of the film, and that Mr. Baldoni, just Baldoni, subsequently engaged a crisis PR specialist, Melissa Nathan, to tarnish her reputation. On December 31st, 2024, Wayfarer and its affiliates sued the New York Times, also in California State Court, for defamation and false light, but did not serve the complaint on New York Times. On the same day, Lively sued Wayfarer in the U.S. District Court for Southern District of New York, also suing various other defendants, including Steve Sauritz, It Ends With Us Movie, LLC, Melissa Nathan, TAG, and Jennifer Abel, Baldoni's publicist. On January 16th, 2025, Wayfarer, along with various other plaintiffs, sued Lively and related parties, also in the Southern District of New York. The court consolidated Lively's lawsuit and Wayfarer's countersuit on January 30th, 2025. On January 31st, 2025, Wayfarer amended the consolidated complaint to add New York Times as a defendant, asserting claims for defamation, false light, promissory fraud, and implied breach of contract. New York Times moved to dismiss on February 28, 2025. No mention of Lively amending her complaint then. New York Times moved to dismiss on February 28, 2025. On June 9, 2025, the District Court dismissed all claims against New York Times with prejudice. The District Court rejected the fraud and contract claims as meritless, and it dismissed the defamation and false light claims on privilege, actual malice, and non-cognizability grounds. After the District Court's dismissal of those claims, New York Times brought this action on September 30th, 2025. New York Times is seeking attorney's fees under New York's anti-strategic lawsuits against public participation statute, also anti-SLAPP, civil rights law, etc., etc. New York Times now moves under CPLR 3212 for summary judgment in its favour, seeking attorney's fees in the amount of $181,622.70. Wayfarer cross moves for a stay of proceedings in this action pending a possible appeal in the federal action. After briefing on the current motion and cross motion, the underlying federal action largely settled. As part of the settlement, the settling parties irrevocably waived any right to appeal orders entered in the federal action, including the order dismissing Wayfarer's claims against New York Times. New York Times asked this court to take judicial notice of the federal settlement. Wayfarer does not oppose this request. Okay, discussion. Wayfarer's cross motion for stay. Wayfarer cross moves for a stay pending the results of the underlying lawsuit. Wayfarer argues that this action is premature and should be stayed because the anti-SLAPP claim rests on interlocutory federal dismissal order that Wayfarer intends to appeal upon the eventual entry of final judgment in the district court. Wayfarer also contends that proceeding in this action creates a risk of inconsistent rulings and wasted judicial resources. Wayfarer also contends that proceeding in this action creates a risk of inconsistent rulings and wasted judicial resources if the dismissal is later reversed. In opposing the cross motion, New York Times responds that a stay is unwarranted because Wayfarer's appeal is merely hypothetical, would be meritless, and is assertedly a delay tactic rather than genuine basis for pausing this action. Regardless of the merits of the parties' respective arguments, in briefing the cross motion, on which the court expresses no opinion, that briefing has since been overtaken by events. In particular, New York Times has put before this court a so-ordered stipulation waiving all parties' rights to appeal rulings rendered in the federal action, and New York Times asked this court to take judicial notice of the stipulation. Wayfarer has not objected to New York Times' judicial notice request, and this court may properly take judicial notice of court filings in other actions. Wayfarer's cross motion to stay is premised on the possibility that Wayfarer could later appeal and obtain reversal of the dismissal of his claims against New York Times in the federal action. Because the settlement in the federal action waives Wayfarer's right to appeal that dismissal, the settlement obviates any possible need for a stay of proceedings in this action. Wayfarer's cross motion is therefore denied as academic. Okay. New York Times motion for summary judgment. On its motion for summary judgment, New York Times argues that it has established as a matter of law that it is entitled to attorney's fees under New York's anti-SLAPP law. In particular, New York Times contends that anti-SLAPP law applies because Wayfarer filed suit in federal court over a newspaper article and video that concern a matter of public interest without a substantial basis in fact and law. Crucially, Wayfarer's cross-motion papers do not offer any arguments on the merits of the anti-SLAPP claim, only arguments in support of the now academic stay request discussed above. This court agrees with New York Times that it is shown as a matter of law that it is entitled to summary judgment on liability on its anti-SLAPP claim. As an initial matter, this court concludes that New York Times may bring this action for anti-SLAPP damages based on the resolution in New York Times' favor of defamation claims against it in a prior federal action. Although anti-SLAPP arguments are most commonly raised in the form of a defense or counterclaim to a defamation suit, New York's anti-SLAPP statute is not so limited. Rather, the statute provides that a defendant in an action involving public petition and participation may maintain an action, claim, cross-claim, or counterclaim. to recover damages, including attorney's fees. That is, as long as a party is a defendant in a SLAPP suit, like New York Times was in Wayfarer's federal action. The party may bring a separate freestanding action for anti-SLAPP attorney's fees, as New York Times has done here. For New York Times to recover attorney's fees under civil rights law, it must first establish that the underlying lawsuit consisted of an action involving public petition and participation under civil rights law. An action will involve public petition and participation for these purposes if the action is based on any communication in a place open to the public or a public forum in connection with an issue of public interest. If plaintiff meets the public participation requirement, then Section 70A allows it to maintain a claim to recover damages. This provision mandates the award of attorney's fees upon a demonstration that the action involving a public petition and participation was commenced or continued without a substantial basis in fact and law, and could not be supported by a substantial argument for the extension, modification, or reversal of existing law. A motion for summary judgment on an anti-SLAPP claim under Section 70A shall be granted unless the party responding to the motion demonstrates that the asserted SLAPP action, claim, cross-claim, or counterclaim has a substantial basis in fact and law, or is supported by a substantial argument for an extension, modification, or reversal of existing law. Whether New York Times was a defendant in an action involving public petition and participation. New York Times argues that the federal action concerns a matter of public interest for civil rights law purposes because Wayfarer's lawsuit against New York Times resulted from the publication of a news article and a video, and that news websites like that of the New York Times are quintessential public forums. This court agrees. The underlying federal action here arose from publicly posted media coverage in the form of both text and video about a legal proceeding brought by a prominent actress in which the administrative complaint alleged sexual harassment and workplace retaliation on the set of a highly publicized movie. I still don't like the fact that they're saying that filing a CRD is a legal proceeding. It is, and Lyman obviously ruled that. But I don't love it. And obviously this judge here is already confused and thinks that there was a California state court proceeding, but there wasn't. From Lively, against Wayfarer, there wasn't. There never was. These are matters of public interest. Holding that the public interest element under anti-SLAPP law was satisfied because the article was published on a public news forum and addressed domestic violence. Domestic violence, seriously? And criminal allegations, both recognised as matters of public interest. The court's conclusion on this point is further bolstered by the expansive scope of matters of public interest under New York precedent. And Wayfarer offers no arguments to the contrary. Accordingly, because the underlying action arose from communications in a public forum concerning a matter of public interest, New York Times has satisfied civil rights law Section 70A's first requirement for anti-SLAPP protection. Okay. Whether Wayfarer's federal claims against New York Times had substantial basis in law and fact. New York Times next argues that Wayfarer brought the underlying claims against it without a substantial basis in fact and law, as evidenced by the district court's dismissal of those claims. The appellate division has made clear that when a given claim is subject to dismissal for failure to state a cause of action, that claim necessarily lacks a substantial basis in fact and law. And Federal Rule of Civil Procedure 12b-6 places at least as demanding a pleading burden on plaintiffs, if not a more demanding burden. Given the dismissal of Wayfarer's federal claims against New York Times, those claims lack a substantial basis in fact and law for Civil Rights Act 70A purposes. And again, Wayfarer has not attempted to dispute this conclusion. The branch of New York Times motion seeking summary judgment in its favor on liability is granted. Whether New York Times is entitled to its claims attorney's fees. New York Times moves for summary judgment not only on liability but also on its claimed damages of $181,622.70. That amount comprises $153,074.70 in fees billed by New York Times outside counsel in the underlying federal action and $28,548 in fees incurred by New York Times in-house counsel in this action. New York Times supports its fee request with a detailed affirmation from its Deputy General Counsel, accompanied by outside counsel invoices and in-house counsel hours logs. Wayfarer does not contest New York Times fee request. This court nevertheless has an independent obligation to determine whether New York Times has established that the amount claimed is reasonable and warranted for the services actually rendered. This court determines that New York Times has shown that it is entitled to most, but not all, of the fees claimed. With respect to the underlying federal action, this court is satisfied that given the complex and high-profile nature of that action, the claimed attorney rates and hours billed on New York Times' motion to dismiss are reasonable. However, New York Times also seeks to recover amounts in fees billed after the district court dismissed Wayfarer's claims against it, primarily fees billed in the course of preparing New York Times' motion for entry of partial judgment under Federal Rule of Civil Procedure 54B to facilitate appellate review of the district court's dismissal order. This court is unpersuaded that these post-dismissal fees were reasonable for purposes of defending against the underlying anti-SLAPP lawsuit, so as to make them recoverable now as anti-SLAPP damages. Excluding these fees, New York Times is entitled to $143,068.20 in damages for the cost of defending the federal action. With respect to this action, the question is whether New York Times should be entitled to recover fees incurred in preparing the fee request branch of this motion, so-called fees on fees. This court concludes that given the legislature's intent in enacting Civil Rights Law Section 70A in its current form to protect speakers on matters of public concern from being silenced by meritless litigation, awarding fees on fees to prevailing anti-SLAPP defendants will appropriately enable them to recoup fully the costs of their successful defences. This court therefore agrees with the conclusion of the motion court in Golan that fees on fees are compensable damages on anti-SLAPP claims. And this court is persuaded that both the billing rates and hours logged in this action are reasonable. New York Times is therefore entitled to a total amount of damages of $171,616.20. Okay, so what they've done is they've said for everything up to, like in the motion to dismiss, basically, and I don't know if that included the motion to stay discovery. It may have. But, everything up to their dismissal in the New York District Court case, Wayfarer's complaint against them, they're entitled to those fees. No problem. They're also entitled to the fees for this state court action. What they're not entitled to, though, is the little bit where they were seeking, like a judgment. They wanted Judge Lyman to enter judgment. This judge is saying, no, you can't recover that. It was unnecessary. Which is, fair. That's fair. I appreciate that. Okay, whether New York Times is entitled to interest on the damages awarded. New York Times has not requested prejudgment interest on its claimed damages, whether in its complaint or on this motion. The court concludes that New York Times is nonetheless entitled to interest. CPLR 5001A provides that interest shall be recovered upon a sum awarded because of an act or omission depriving or otherwise interfering with title to or possession or enjoyment of property. For these purposes, property encompasses both tangible property and intangible property, such as money. A party suing under Civil Rights Law Section 70A is seeking damages for interference with the possession or enjoyment of intangible property in the form of money, namely the amount of fees that the party has had to pay its attorneys to defend against and seek compensation for, a SLAP suit. Thus, CPLR 5001A, by its terms, requires the award of interest on damages awarded under Civil Rights Law, Section 70A. The next question is whether it matters that New York Times has never requested interest. The court concludes that it does not matter, and I do agree with that. I mean, I suppose in a way that they although they didn't expressly say, hey, can you give us an award of interest on any damages or fees or costs, they haven't expressly said that, which is what the judge is saying, but he's saying, well, should I still give it to them? And the thing is quite often attorneys will also put in, we request this relief, or this relief, and then they'll put like a little catch-all, which is and any other relief that the court deems just and equitable and all that. So that would cover that. So, the judge is then right to say, well, actually, this statutory provision says you're entitled to interest. I'm going to give it to you. The Court of Appeal has held that pre-verdict interest under CPLR 5001 should be awarded notwithstanding the absence of a demand for interest in the complaint. The Appellate Division has also held that post-verdict pre-judgment interest under CPLR 5002 must be awarded as a matter of right, regardless whether the movement has made a specific demand for interest in the motion being resolved. But there appears to be a curious dearth of New York authority on whether a plaintiff or counterclaimant that has successfully moved for the award of a money judgment in its favour is entitled to pre-judgment interest under CPLR 5001, notwithstanding the absence of a demand in the motion. The court concludes that a plaintiff must be awarded interest under CPLR 5001 regardless of this demand. The relevant language of CPLR 5001 and 5002, providing that interest shall be recovered, is the same. The principle underlying pre-verdict and post-verdict interest is the same, that the breaching party should compensate the wrong party for the loss of the use of the money awarded in damages. And the Court of Appeals held in Flam that when the award of interest is a matter of right, a plaintiff's failure at trial to request timely an award of interest before or after the verdict does not affect the plaintiff's entitlement to interest. These authorities all point to the same direction. A plaintiff otherwise entitled to an award of prejudgment interest under CPLR 5001A as a matter of right does not lose that entitlement by failing to ask for interest. As for that interest accrual date, this court concludes by analogy to attorney fee awards made under Real Property Law Section 234 that interest should accrue from the date on which Wayfarer's claims are determined to have lacked a substantial basis in fact or law within the meaning of the Civil Rights Act Section 70A, i.e. the date of this order. Accordingly, it's ordered that Wayfarer's cross motion for a stay is denied as academic. It is further ordered that the branch of New York Times motion seeking summary judgment on liability is granted. It is further ordered that the branch of New York Times motion seeking summary judgment on damages is granted in part and denied in part as set forth above. And it is further ordered that plaintiff, the New York Times, is awarded a judgment against defendant Wayfarer Studios of $171,616.20 with interest running at the statutory rate from July 27th, 2026, plus costs and disbursements as taxed by the clerk upon the submission of an appropriate bill of costs. And it is further ordered that New York Times serve a copy of this order with notice of its entry on Wayfarer and on the office of the county clerk, etc., etc., which shall enter judgment accordingly. So there we go. So that's the end of that case now. It's all wrapped up. I'm sure Wayfarer paid that bill incredibly quick to, keep the interest costs down. So yeah, and I think this is fair. I think I've said all along, at the end of the day, whether I don't agree with what the New York Times did or the part they played, but at the end of the day, they come to this court. They were sued unsuccessfully for defamation. New York Times then filed an anti-SLAPP. That was it. The case against them, the defamation claims against them were dismissed for failure to state a claim, amongst other things. That is all they really needed. So it was for me, it was almost inevitable that they were going to get an award of attorney's fees and costs. But I do appreciate the judge sort of saying, hold on a minute, I'm not going to give you everything. You're not entitled to this bit. So he's looked very carefully. I'm hoping Lyman will do the same with Lively's ridiculous, 8 million demand for fees. We will see. We'll see. But this is not unexpected. I think Wayfarer also saw this coming as well. And that's why they kind of put it in their opposition to Lively's demand for fees. They're like, hold on a minute now. If anything, New York Times have only asked for this amount. If anything, she should get this, the same amount and nothing more. So, yeah. All right, guys. I've got a few updates in the Darren Henson case, in the Harco Insurance case, and in the Taylor Swift case. So I will do some videos over the next few days. But it's great to be back.